Hi everyone, welcome to the Building and Construction Update for 2022. My name's Brianna Anderson. I will be presenting today on some recent cases regarding misleading and deceptive conduct. Richard Cheney SC will be presenting on the issue of limitation periods, and Frank Hicks SC will be presenting on the issue of liquidated and nominal damages. Just some housekeeping quickly. Anyone that's joined using the Starleaf app, you can raise your hand using the raise hand button to ask a question. Move your mouse over the screen and a task bar will appear along the top, and the raise hand button's in the centre of the task bar. You can also ask questions using the chat box on Starleaf and on the live stream. So the case of Mistrina Pty Limited and Australian Consulting Engineers Pty Limited 2020 New South Wales CA 223 is the case that I'll first be speaking about. And that was an appeal from the decision of His Honour Justice Hammerschlag and was heard before McFarlane, Ward and Leeming in the Court of Appeal. The facts of this case were that Mistrina, who's a developer, entered into agreement with Jabcorp, the builder, to construct a property in Brighton Le Sands. There was also a tripartite deed involving both Mistrina and Jabcorp, as well as Bankwest, which provided Bankwest with step-in rights and various security in the event that they wanted to exercise those rights. Now, Jabcorp had engaged the respondent in this case, which is Australian Consulting Engineers. They provided a certification of the design of the raft slab and said that it was compliant. Construction commenced at the property and in reliance on that certification. And when the works were quite well advanced, it was found the slab was defective and non-compliant. Works stopped at that point. There was some serious concerns about the safety and the impact on one of the neighbouring properties. And there were serious delays due to that defect and trying to resolve it. Ultimately, Bankwest exercised its step-in rights and then sold the partially completed project, as well as exercising, there was other security rights, including a guarantee from the director of Mistrina, and also another mortgage on another property was included as security. Mistrina commenced proceedings and claimed for the loss of opportunity to make a profit on the development due to the misleading and deceptive conduct of Australian Consulting Engineers in providing the certificate. Ultimately, in the Supreme Court, His Honour found that causation had not been established. Mistrina failed to adduce evidence sufficient for the factual finding that the structural defect and delay were a material factor in Bankwest exercising the step-in rights. And he also found that it was a matter of conjecture that the structural defects causally contributed to Bankwest enforcing its step-in rights. Now, it wasn't in dispute that the engineers engaged in misleading and deceptive conduct in providing the certificate, and that the building would not have been constructed but for, or at least in accordance with that design, but for the certificate. On appeal, Mistrina challenged the finding that the misleading and deceptive conduct did not cause the loss. The engineers also cross-appealed various allegations, including the primary judge ought to have found that Mistrina failed on the balance of probabilities that they would have been afforded the opportunity they claimed to have lost. And there was a finding in the event that His Honour was incorrect in relation to the causation argument. He found that there would be a 15% discount to the loss of opportunity. And on cross-appeal, the engineers sought to say that 80 to 90% was more appropriate. Now, a factual scenario, which I didn't raise before, was that the loan was due to be repaid in August and the expert evidence indicated that but for the certificate and the stop works, the likely date for completion would have been September. So on that basis, it is likely that Mistrina would have also been in default as at that date anyway, and accordingly, Bankwest still may have exercised its step-in rights. Now, Mistrina argued that His Honour incorrectly applied the findings in Henville and Walker, 2001, High Court of Australia 52. And that case says that the reliance of the representee is either the decisive consideration or one of for taking the course of action in question. And because it is decisive, the misrepresentation is correctly seen as causally connected with the course of action that follows. They also argued that once the primary judge concluded that the certificate was at least one of the decisive considerations, there was no need to embark on the inquiry as to causation. And because the misleading and deceptive conduct need only have materially contributed to the loss, it would be rare that damages would be reduced. They also argued that the onus is on the defendant in relation to any discount to be applied. They also argued that the proper inference on the evidence was that the structural defects and delays caused Bankwest to exercise its rights. They said that it was significant that there were various unknowns in relation to the defective slab and the delays, which created significant uncertainty. And the evidence did not support the proposition that Bankwest would have taken the work out of the hands of Mistrina in circumstances where the works were almost going to be complete in August 2010, which is when the loan was due, and that the only material change when Bankwest exercised its rights to step in was the structural defect and delays. It wasn't in dispute that the structural defect was an event of default, so that wasn't an issue. And they relied on Gaudron's comments in Boland and Yates, which related to liability for contravention of Section 18 of the Australian Consumer Law, which was the Trade Practices Act at the time. And that was that it doesn't depend on the proximity or the reasonable foreseeability of the loss, and that the event that occurred was foreseeable even in a general way. And I've just talked about those. And they also challenged the finding, they said that His Honour erred in holding that their case was based on conjecture, and that just comes round to the fact that there wasn't strict or explicit evidence of what Bankwest would have done but for the defects. Now, Australian Consulting Engineers said that there was no evidence on the basis of the decisions made by Bankwest, and that His Honour correctly identified the principle in Henville but didn't need to apply it because the appellants failed as a question of fact to prove that the misleading and deceptive conduct was a cause of Bankwest exercising its step-in rights. They said that the causative requirements were not met simply because there was a factual connection, and that it couldn't, not enough to point to some chance of a beneficial outcome, and they must have established on the balance of probabilities that they would have been allowed by Bankwest to complete and realise the development, even in the face of the evidence that indicated they would have finished or likely to finish the project after the date the loan was due. And accordingly, because of the uncertainty around that, that a discount of 80 to 90% should be applied instead of 15%. So the decision of the Court of Appeal was that the primary judge had the correct legal principle, that it was sufficient for Mistrina to establish that the conduct complained of played a material part in Bankwest's decision to step in, for it to have established causation. And they found that he erred in not finding that the structural design defect issue was a material cause for Bankwest taking over the development. They considered there was an overwhelming inference that the cessation of the building works due to the structural defect was a material cause of Bankwest's decision to step in, and it was not mere conjecture. They chose not to decide explicitly on whether the questions of remoteness are relevant to misleading and deceptive conduct claims under the ACL. They also considered the loss suffered was foreseeable, even in a general way, and that in relation to the discount for loss of opportunity, that these claims and issues exhibit characteristics of a discretionary judgment, and the court would be reluctant to intervene unless the exercise of discretion miscarried. The lessons to take from this is that engineers and third parties can be liable for misleading and deceptive conduct in relation to loss suffered by a developer, notwithstanding that their agreement is with the builder. Direct evidence need not be required to hold a third party liable where inferences can be drawn. The loss can be generally foreseeable, and there's still no decision as to whether the foreseeability test is relevant to the issues of damages in relation to the Trade Practices Act or the consumer law. The engineers did actually make a special leave application, but that was refused in March 2021. Ultimately, the engineers had to pay Mistrina $2.3 million and $1.1 million to the director in relation to the sale of the property that was used as security. Another case which I'll just go over quite quickly is owners of Strata Plan 87265 against Saab and also against Alexandrova, 2021 New South Wales SC 150. This is a really interesting case and quite factually complex. But essentially, the Owners Corporation brought proceedings against Mr. Saab for the breach of the statutory warranties because he was the builder named in the contract with the developer who had gone under by this stage. Now, the case of the Owners Corp was that Mr. Saab had authorised his nephew to enter into the contract on his behalf and deal with the insurance broker on his behalf. Mr. Saab denied giving such authority, says the documents were forged and brought into existence without his knowledge, that he didn't do any of the work. In fact, he said he didn't know about it until they were quite advanced. The case against Alexandrova was brought almost in the alternative in the event that the claim against Mr. Saab failed, which is ultimately what happened. The court found that he didn't do the work and wasn't a party to the contract. But that effectively left the owners with a situation where they were not able to enforce the statutory warranties as against him. And because it was found that he had not authorised the home warranty insurance application to be made, that was also fraudulently obtained, and accordingly the owners essentially were without any ability to recover for what were fairly significant defects, in the end about $3.4 million. So the case against Alexandrova was that she had impliedly represented that she had authority to apply for the insurance, and that her conduct was misleading and deceptive and was a material cause of the issuance of the insurance policy, and then that ultimately resulted in the construction of the building taking place, which therefore caused the defects. So it was ultimately found that Miss Alexandrova's conduct was misleading and deceptive and was a link in a chain of causation that has the requisite degree of proximity to the loss suffered. So those are two cases where there's been a misleading and deceptive conduct by a third party, yet found that the causal connection was sufficient to establish the loss and damage. And now we move on to Richard.
Thanks, Brina. Must say it seems a bit odd speaking into an empty room. We're used to conducting CPDs in this room with a lot of people present. I was given a fairly broad mandate. I was to speak about Limitation Act authorities as they bear on the building industry or on building law, and I chose to very much narrow that mandate to discussing a single case. The decision of the 5 justices of the High Court delivered last year, Price and Spohr. the decision relates to the enforceability of contractual provisions that purport to limit or exclude the effects of limitation legislation. And the facts in Price and Spoor were remarkably simple. The parties had entered into 2 mortgage contracts over land securing borrowings of about $4 million, and the borrowers defaulted on the loan repayments. And the lender, as mortgagee, sued on the mortgages, seeking to exercise its rights to sell the mortgaged land and to recover its debt. And relevantly, the Queensland Limitation Act prescribed the time within which actions for the recovery of monies secured by mortgage must be brought, and it did so via 2 provisions. Section 13 of the Act, which provided that an action shall not be brought by a person to recover land after the expiry of 12 years from the date on which the right of action accrued. So firstly, a 12-year limitation period, and then a second provision, section 24, which provided that where the period of limitation prescribed by the Act within which a person may bring an action to recover land has expired, the title of that person to the land shall be extinguished. So the 2 provisions, section 13 imposing the 12-year limitation period and section 24 operated to, in effect, see one's rights in the land extinguished after the expiry of 12 years, or at least the title to that land. And the mortgages contained a clause, clause 24, that relevantly provided that the provisions of all statutes by which the powers, rights and remedies of the lender may be defeated or extinguished shall not apply hereto and are expressly excluded insofar as this can lawfully be done. So in effect, the mortgage purported to exclude the operation of the relevant provisions of the Limitation Act in Queensland. And unsurprisingly, as I said earlier, the borrowers defaulted on the loan repayments and unsurprisingly, the lender as mortgagee sought to exercise their rights to sell the mortgaged land and recover the debt. And the borrowers alleged that the action was time barred and that the rights had been extinguished by operation of sections 13 and section 24 of the Limitation Act. And unsurprisingly, the lenders relied on the covenant in clause 24. And just as a reminder there of what the clause 24 covenant provided. And the lenders argued, in effect, that clause 24 had the effect that any extinguishment of the interests that were effected by the Limitation Act was excluded by the parties' earlier agreement. And the borrower's rejoinder to that argument was that clause 24 was unenforceable because it was contrary to public policy. They argued, in effect, that as a matter of public policy, parties should not be permitted to contract out of a limitation defence, and so that clause 24 was, on their argument, not enforceable to defeat their reliance on the Limitation Act. And that argument found favour with the trial judge. He upheld the borrower's argument and held that the lender, the mortgagee's action to recover the land was time barred. That decision of the trial judge was reversed by the Court of Appeal. It held that the parties had lawfully contracted out of the relevant provisions of the Act and that doing so before any cause of action had arisen was not contrary to public policy. And I suppose it's always hard to know what feature of an appellate decision motivates the grant of special leave by the High Court, but I suspect that it was the public policy issue that attracted the High Court's interest here. All 5 judges of the High Court rejected the borrower's argument and upheld the clause. That is, they held that the clause could be enforced by the lenders, with the result that they could enforce their security over the land as unpaid lenders. And the judges arrived at that position by different routes, but all 5 of them referred to an earlier decision of the High Court in Westfield Management and AMP Capital Property Nominees, 2012, volume 247 of the CLRs. In that case, it was held that a person upon whom a statute confers a right may waive or renounce that right unless it's contrary to the statute to do so, which is a principle that involves construing the entirety of the Act to decide or to determine whether a contract that purports to, or a party who purports to waive that right may lawfully do so. And the judges in Price and Spoor reasoned by reference to the Westfield and AMP decision, and from the fact that the Queensland Limitation Act contained no express prohibition against contracting out of it, and further that the Act merely gave the defendants a right to plead extinguishment when a limitation period has expired, rather than effecting an automatic extinguishment of title upon the expiry of that period, that permitting the parties to bargain away such a right was not contrary to the statute. And in so concluding, the judges also referred to an earlier decision of the High Court in Commonwealth and Mewat to the effect that in a statute of limitations, a statutory bar does not go to the jurisdiction of the court to entertain the claim, but rather to the remedy available. And unless a defence relying on the statute is pleaded, the statutory bar does not arise for the consideration of the court. And there may be many reasons why a defendant who has the protection of a limitation period may nevertheless elect not to plead it. And it occurs to me that often that's the case with public authorities who acknowledge a breach of duty, or at least acknowledge some causative breach of duty on their part, and make a public policy or a policy decision to not take a limitation point that would otherwise be available to them. But in any event, I think that what's common to all of the judgments in Price and Spoor is a simple rationale that, given that the Limitation Act establishes rights that a defendant can always elect not to exploit, that is by simply not pleading that the action is time barred, why should it be regarded as contrary to the Act to permit a defendant to contract out of those rights before the cause of action even arises? And the joint judgment of Her Honour the Chief Justice Kiefel and Justice Edelman, I think, establishes 5 propositions that I've put on the slide, and perhaps I'll just let people read those 5 principles. Justice Stewart, who delivered a single judgment, took a slightly different approach. He concluded that a party may agree to promise not to invoke a limitation defence as part of a contractual bargain, and held that an agreement to exclude a statutory limitation period may be enforceable. He emphasised that it first involves an exercise of construing the Limitation Act to determine whether contracting out of it is contemplated or permissible. He said in that case, in the case involving the Queensland Limitation Act, it was open to the parties to exercise their freedom of contract by including Clause 24, and went on to hold that the common law does not recognise a public policy independent of the Limitation Act of finality in litigation. And I think Justice Stewart was the only judge to go into that territory. So the issue is, what are the implications, particularly for building practitioners, of the decision in Price and Spoor? On one view, there's no news here. It doesn't break any new ground. It's simply another example of the application of the earlier reasoning in Westfield and AMP to the effect that parties may contract out of statutory protections unless to do so would be contrary to the intention of the statute itself. But the judges in Price and Spoor observed that there appears to be no authority in Australia dealing directly with the question whether a contractual provision precluding the pleading of a limitation defence entered into for consideration before a cause of action to which it might be pleaded is void against public policy. So at least the decision has put that issue to bed. But it seems to me there's potentially wider implications that long authority from the High Court has recognised that the policy of the law may regard a contract as unenforceable where it operates to defeat or circumvent a statutory purpose or policy according to which statutory rights are conferred in the public interest, notwithstanding that the statute may not contain an express prohibition on contracting out of such protections. And that policy has perhaps most frequently been seen to be applied in cases in which, for example, misleading deceptive conduct in contravention of the Trade Practices Act or the Australian Consumer Law or its state equivalents has been alleged in cases such as Mistrina that Breena spoke about earlier. But for those of us who practice in the professional negligence field in particular, there's long been uncertainty, not yet resolved by the High Court, about whether provisions, for example, in contracts for professional services that purport to exclude or limit liability for misleading and deceptive conduct are void as contrary to public policy. And the uncertainty in part seems to stem from inconsistent decisions both among the justices of our own Supreme Court, but also between decisions of those interstate. And those inconsistent decisions could perhaps be the stuff of another CPD, but it's possible, I think, that the decision in Price and Spoor indicates that this current High Court might want to take a wider look at the so-called exclusion principle, or the Henjo principle that was first espoused by Justice Lockhart in the Federal Court in the Henjo case. In that case, the principle was put this way, that the public policy which lies behind the court's refusal to allow a party to contract out of liability under what was then Section 52, now Section 18, is not exhausted by application to the case of an exculpatory provision which is contained in a document into which the complainant has been induced to enter by misrepresentation. It must extend to any document which purports to excuse a misrepresentor from liability for contravention of Section 52, Section 18. And older practitioners might recall there was a long controversy before Henjo at least about whether provisions that purported to exclude liability for misleading and deceptive conduct could be relied upon in circumstances where the misleading and deceptive conduct itself induced the aggrieved plaintiff to enter into the contract in the first place. And Henjo made it clear that that those provisions to that effect won't be effective to preclude liability for the misleading, for the party who misled. But the reach of that of the Henjo exclusion remains controversial, in part because we're all waiting to hear what the High Court has to say about it and hopefully resolve some of the conflicts between the authorities. And it's a matter of keen interest for engineers and architects and other building professionals and their insurers who attempt to cap their liability to a fixed amount or a multiple of fees paid, or alternatively to limit the time by which the principal must bring a claim, because those provisions to that effect have been struck down by some authorities as contrary to public policy. And I think Price and Spoor might indicate that if a suitable vehicle comes along for testing the Henjo principle, then special leave might be given. And perhaps one final and more obvious implication is that for those at the front end drafting building contracts, particularly on behalf of project principals, they might want to consider whether Price and Spoor gives scope for excluding Limitation Act time bars that can be of some moment, given how commonly defective work is not manifest within the time periods imposed by such legislation. That was all I was intending to say. I might call on Frank Hicks, SC, to speak about liquidated damages and other matters.
Before you do, I don't know if people can hear this.
This is a question from Frank Hicks himself.
Yeah, that's right. Trying to defer my visit to the lectern as long as possible. You and I, Richard, had a discussion about what it would mean in the context of litigation, where it was held in Price and Spoor that, well, not held, but reiterated in Price and Spoor that limitation defence is a matter of pleading and it goes to the remedy, not the right. How extensive then does your pleading need to be? For example, Brianna and I were in a case last year in which they had pleaded a limitation defence based on a certain factual matrix, which ultimately they couldn't make out, and they tried to shift the limitation defence to the facts as they were ultimately found on the evidence. Now, in that decision, Justice Stevenson still didn't grant them, but is it a case that if you're going to plead limitation that you are going to be held to your contentions? Or should it be?
Well, I think very much so. Those who, I mean, I always advocate, if you're for a defendant pleading limitation defence, that you give as few particulars as possible. But because you, but recognising that, I think limitation defences are one of the matters that the rules stipulate must be pleaded. In that rule, whatever 14.14, I think, is it, that provides that. And so it would seem to follow from the fact that it's mandatory to plead them if you want to take the point, and consistently with Price and Spoor, that if you're going to plead the limitation defence, you need to be precise about it if you want to then later rely upon it. All right. You can't put it off any longer, Frank.
Apparently not. Well, good evening, camera, and good evening those that are viewing through the camera. I agree with Richard, these is difficult circumstances to be speaking to a, I wouldn't say quite empty room, because Brianna's still here, as is Richard. I have been tasked with reviewing certain decisions that concern the issue of liquidated damages that have come across, or at least to my attention, over the last little while. They're 3 decisions in Australia and 2 decisions in the United Kingdom. They do go back a little bit, but I think the most recent was just before Christmas of last year, a decision of Justice Digby that I'll come to shortly. The first decision that we're going to have a look at is Capello and Hammond and Simmons, New South Wales Proprietary Limited. This is the first instance decision of His Honour Justice Ball, and it concerns a not uncommon event where owners had been convinced, if they'd been advised at all, to enter into a contract whereby their liquidated damages provision was the princely sum of $1 a day. Now, I think we can all agree that $1 a day is nominal to the point of negligible in respect of any loss and damage that might arise from failure to complete by a specified date. And the builder submitted in that case that the entitlement of the plaintiff was limited to $1 a day in accordance with those contractual provisions and with the line of authority that is well established, whereby if parties genuinely pre-estimate an amount for the purposes of liquidated damages, then they are taken to exclude the right for general damages arising from the failure on the part of the builder to complete the works by the nominated date, the classic establishment of general damages for breach of contract. And it was held, or at least submitted, that the whole point in a clause providing for the payment of liquidated damages is to avoid the expense and time in quantifying the actual damages for breach of contract arising from delay in completing the works. And I'm sure that practitioners in this field are familiar with the notion that a rate for liquidated damages may be considered to be a penalty where it is not a genuine pre-estimate of damage, but simply an arbitrary sum fixed with a view to compelling performance of the contract in terrorem. This is something of the converse of that position, whereby rather than having an amount which is not a genuine pre-estimate but simply a large figure to scare the builder into performing, we have a pre-estimate which is really not genuine, unless someone seriously thought their loss was going to be $1 a day. I don't imagine what they thought they'd be losing that would only cost $1 a day for failure to complete. Whether or not that is binding with respect to that line of country, as I say, whereby agreeing that figure, the parties are taken to exclude general damages. And indeed, at paragraph 27 of the decision of Justice Ball, the question was said to remain whether by inserting a nominal amount as the amount payable, the parties intended, in effect, to exclude by the operation of liquidated damages the right to damages for delay altogether. Now, the interesting aspect of this decision is that Justice Ball approached it from two, which he found to be tied together perspectives. This was a contract in respect of residential building work. There is, as we would all be familiar, under the Home Building Act in New South Wales, a suite of statutory remedies, one of which is a warranty that the work will be completed within the time stipulated by the contract. Associated with those statutory warranties is a provision which precludes contracting out, section 18, capital G. So His Honour Justice Ball considered that the question as to whether, simply as a matter of contract, the parties considered the nomination of a rate of $1 a day to exclude general damages to be a matter which needed to be considered in the context of the statutory provision, which excluded a provision or excluded a term which purported to contract out of the Home Building Act. Ultimately, in this case, Justice Ball found that because there was a provision under the Home Building Act which precluded contracting out, a provision which under a contract limits a party to claiming nominal damages for a breach of that warranty has the effect of restricting the rights of that person in respect of such a warranty, since it substitutes for a substantial right for its breach a nominal one, and it was therefore void under section 18G. His Honour then went on to say it follows from what he had said that the better interpretation of the liquidated damages clause is the one that avoids that consequence. So whilst His Honour Justice Ball in this decision focused upon the statutory regime to reach a conclusion with respect to the contractual provisions, I think it is certainly reasonably arguable to conclude that where parties have, rather than reach a genuine pre-estimate, but simply put a nominal figure by way of liquidated damages in their contract, they are not intending to displace an entitlement to recover damages at all with respect to the failure to complete by a particular date, but they are in effect eschewing the possibility of a genuine pre-estimate being used and the benefit that that can have to avoid the expense and time in quantifying loss that would otherwise cover or come from that breach. So that's the first decision that I wanted to alert you to. It's the citation up there, 2020 NSWSC 1021. The second decision that I wanted to talk about is one called Built Queensland Pty Limited and Pro-Invest Australian Hospitality Opportunity brackets STM brackets. AHO up there stands for Australian Hospitality Opportunity. Now, this is a decision from Queensland which concerns the appropriate methodology associated with the assessment of delay. As those of you who practice in this area will probably know, if you speak to two programmers, you're usually going to get at least three methodologies put forward as to how delay might be analysed, each of which will yield numerous conclusions and reasons, none of which will necessarily be attendant to or correspondent with any of the others. So there is any number of methodologies that might be adopted. Certainly there is a protocol that was issued by the United Kingdom Society of Construction Law, which I think nominated at least 6, but then referred to perhaps another 4 or more, and each of which seeks to provide some rational basis for assessing the issue of time. Now, without getting too philosophical, time is obviously a very deep concept that a lot of people have thought about for a long, long time, and certainly not in something as mundane as construction projects. But nonetheless, it still needs to be considered. And in this case of Built Queensland and Pro-Invest Australian Hospitality Opportunity, the classic dichotomy of a prospective delay analysis as opposed to a retrospective analysis was the subject of contest. Now, I'll just start briefly with respect to this decision by observing that in this case, the prospective approach that was adopted involved the expert undertaking the following steps. Firstly, considering the statist program that was issued prior to the commencement of the alleged delay, determining criticality or otherwise of the relevant activity prior to the delay occurring, reaching an opinion as the impact of the delay on the date for practical completion by introducing a delay activity into the program to model the claimed delay, and then considered programming or programs that were produced during that period the delay was occurring to determine whether the criticality of the relevant activity was maintained. So effectively, stepping back in time, looking to the events as they were, the circumstances as they were known, and the programs as they were issued when the delay event occurred, to look forward without the benefit of hindsight as to whether or not the contractor was in fact delayed. The second approach, the retrospective analysis, looked at what is described as planned versus as built, and this looked with hindsight to determine that the relevant activity was on the critical path during the period of the claimed delay, determined which work activities within the relevant activity were on the critical path, and compared the planned and actual duration for the relevant activities that were on the actual critical path. Now, this issue of methodology as between programming experts was sought to be resolved in this instance by, unsurprisingly, the terms of the contract. It has come up before, and it came up before His Honour Justice Flanagan in Civil Mining and Construction Pty Limited and Wiggins Island Coal Export Terminal Pty Limited. The medium mutual citation for that case is square brackets 2017 end square brackets QSC 85. And they were dealing with a form of contract which talked about the contractor who is or will be delayed, which might suggest that what was envisaged was a prospective analysis of what was to be done. And indeed, in another decision, a Western Australian decision in this case, called CMA Assets, formerly known as CMA Contracting, and John Holland number 6, medium mutual citation for those following at home, square brackets 2015 end square brackets WASC 217, that form of words, that is to say is or will be delayed, was considered to determine that a prospective analysis was required. In this case, however, because contracts can be read variously and sometimes the language is inconsistent, whereas it did refer to the contractor, that is to say, is or will be delayed, further in the clause, it required that the superintendent be satisfied that the work under contract, or the WUC, was actually delayed. So the language there spoke of a retrospective analysis. So on the one hand, the contractor is or will be delayed. They then have to take certain steps, and we'll all be familiar with those in this field, of making a written claim within a specified period of time so as to maintain an entitlement to an extension of time. But When that claim came to the superintendent had to be satisfied, past tense, that the work under the contract was, past tense, actually delayed, past tense. So it is looking retrospectively to consider what effect this event actually had on the work as performed. And in this decision, as with Justice Flanagan's approach in the Civil Mining and Wiggins Island Coal Export Terminal case, the judge said it can be both. So both the prospective and the retrospective delay analysis was allowed by Justice Flanagan in Civil Mining and Wiggins Island Coal, but also in this case of Built Queensland and Pro-Invest Australian Hospitality Opportunity Proprietary Limited. So ultimately, it didn't provide too much guidance beyond saying it's important to examine the terms of the contract to determine whether or not the methodology your expert wishes to adopt is consistent with it. And it will be necessary to find within your contract terms which direct attention to that methodology, or at least allow it to be exercised. There's not really much more to be gained from that, but to observe that in that case each way was allowed, and the judge was then left with having to make the best that he could with those two competing analyses. The third decision, the last Australian decision that I wanted to bring to your attention, was delivered on the 22nd of December 2021. It was a decision of His Honour Justice Digby in a case called V601 and ProBuild, one of the last acts of ProBuild before it's gone into external administration, it would seem. Now, I'm not sure if this is one of the projects that caused ProBuild to have the problems that it's so publicly seen to have had, but this was a set of litigation in which there were many, many claims made. This is a very long decision. It's in excess of 400 pages. And the relevant parts that I'm looking at start at paragraph 1223. So you're welcome for me finding that part of the judgment and allowing you not to have to wade through everything that preceded it. To be fair, it's got an index, but nonetheless, 1223 is where you need to start. Now, at paragraph 1223, His Honour Justice Digby considered ProBuild's acceleration claim. Now, this was a claim that ProBuild brought forward on the basis that it had made certain EOT claims to the contract administrator, superintendent, doesn't quite matter what their official title was, the person who was required to determine those claims. Now, those claims had been rejected, ProBuild said wrongfully, and ultimately they were found to be correct. They were entitled to extensions of time. Those claims had not been granted. What ProBuild said in this case was, well, because you didn't grant us extensions of time, and we were therefore compelled to continue our work by accommodating these events, brackets for which we were actually entitled to extensions of time, end brackets, and because we were facing liquidated damages, which we naturally wish to avoid, and indeed comply with our obligations, we had to accelerate the works. And in doing so, we devoted more resources, management, labour, etc., to ensuring that the works were completed, and these events of delay, which impacted our ability to perform the work and for which we should have been granted extensions of time, cost us an additional $1.83 million. And ProBuild said that they are entitled to those acceleration costs in three ways. Firstly, they are damages for breach. They are damages that we've incurred that we would not have otherwise incurred because the superintendent failed to provide extensions of time as he or she should have done, acting reasonably in accordance with those obligations that are imposed upon superintendents, both pursuant to cases such as Perini, but also pursuant to those terms of a contract that we're all familiar with. Because of the actions of the superintendent, which were in breach of those obligations, this is loss and damage we've incurred. The second way that ProBuild said that it was entitled to these monies was that following the breach, we were suffering loss and damage, and in order to mitigate that loss and damage, we had to expend monies. And it's a classic circumstance that where an innocent party spends money in mitigation of loss, it is entitled to recover those costs in mitigation. The third way that they submitted this acceleration claim was to say that the directions refusing the extensions of time that was claimed effectively were a direction to accelerate, because the term direction was very broadly defined in the contract, and therefore in the circumstances, having regard to the whole of the events and what had occurred, and the fact that they were indeed entitled to extensions of time but were refused, the court should consider those directions rejecting the extensions of time to be in effect directions to accelerate, thereby bringing the claim within the provisions of the contract, which were quite detailed and which did allow an acceleration claim where the contractor was directed to accelerate. Now, as I've summarised there, His Honour Justice Digby held that ProBuild was entitled to the costs of acceleration, both as loss and damage for the breach occurring when the superintendent failed to act reasonably, it being an office which the principal had to ensure was occupied by someone who acted reasonably, in refusing the extension of time claims. Further, it was entitled to those monies as the costs of mitigation in circumstances where it would suffer loss and damage, potentially the imposition of liquidated damages or other losses, had it not attended to the circumstance it was presented with, which was to complete the works in a shorter time frame than it was otherwise truly obliged to do. The third argument, perhaps the most imaginative, which was a rejection of an extension of time claim, is in effect a direction to accelerate. Justice Digby did not accept that, gave it fairly short shrift and simply said, well, a direction which is expressed to be in respect of one thing and for one matter only should not, in its terms or in its proper construction, be taken to be a direction for the purpose of some other part of the contract. And he observed that obviously there was contractual provisions for extensions of time, allocated specific numbering, etc., whereas there were also provisions for the directions to accelerate. And it was not a proper construction of the contract to transpose a direction given with regards to an extension of time to be a direction under another part of the contract to accelerate. I won't go through all of the parts of Justice Digby's analysis. It is worthwhile reviewing, however, because His Honour did spend a tick over 100 paragraphs dealing with the various cases, the parties' submissions, the reasoning, going back to matters of the implied term in Perini and other quite well-known cases. It's a good refresher, but it is also a matter worth considering that where you have these sort of extension of time claims and you can show that resources are devoted to having the works keep up with the time frame that is determined by those extension of time claims that are not allowed, there is another way to seek to recover those costs where that loss and damage can be shown. I'm probably filling out the time a little bit better than I was actually hoping, so I'll move rather quickly through these last two cases. The first one is of Triple Point Technology and PTT Public Company. This is a decision of the UK Supreme Court. The medium neutral citation up there is 2021 UKSC 29. This is an interesting case, more because of the way in which it was dealt with at the lower level than here, because what the intermediate court said was that a clause which said if a contractor fails to deliver the work within the time specified and the delay has not been introduced by the principal, contractors shall be liable to pay the penalty at a rate of 0.1% of undelivered work per day from delay from the due date for delivery up to the date PTT accepts such work, etc., etc. And what the intermediate court said was, sorry, I should take a step back. PTT never accepted the work. They were late, there was a lack of performance, the work was never ultimately accepted. But they claimed liquidated damages as an accrued right, as and from the date that the work ought to have been finished. And the intermediate court accepted the rationale which said, well, this clause only applies in its terms, and if the work is never actually finished, then it has no occasion to apply, and therefore there's no right to liquidated damages. Now, the United Kingdom Supreme Court rather regarded that as not an appropriate characterisation or rationale, and starting at about paragraph 35, talked of the difficulty of this approach being inconsistent with the commercial reality and accepted function of liquidated damages, and that parties agree to liquidated damages so as to provide a remedy that is predictable and certain, and that the parties must be taken to know the general law, namely that the accrual of liquidated damages comes to an end on termination of the contract, and that those accrued rights may be exercised. It's a fairly straightforward and what I would consider to be, with all due respect, commercial analysis of these sorts of provisions, as opposed to the very literal approach that was taken in the court below, which did disallow the entitlement to liquidated damages, accrued rights as we would understand them, because the condition of acceptance of the work never actually came to pass, where, as in many cases that we will have encountered, that was because the contract was terminated, not least reason for which was the contractor's failure to actually complete on time. The last case that I'll quickly deal with, because it's probably of somewhat limited utility, is Echo World and Dobler. The screenshot or the slide sets out the provision. The interesting part of this case was that there was a liquidated damages clause which was said to be a penalty, and it was found not to be a penalty, so this whole reasoning became somewhat academic. But what was done in this case before Her Honour Ms Justice O'Farrell was a consideration of an argument that said, well, where you have a clause that says £25,000 per week, up to an aggregate maximum of 7% of the contract sum, if the $25,000 a week is a penalty, does the aggregate maximum still nonetheless cap the damages? Now, there's all sorts of cases that are dealt with in this decision which describe a penalty clause as one which is unenforceable at all, unenforceable for all reasons. There is, in fact, a very nice quote that I hope to work in at some point in my own submissions, although the difficulty with it is I cannot for the life of me pronounce the name of the case. It's Wall and Reddy-Ricketard Tia Bolla-Gat Lugat, I kid you not. Square brackets 1915, 3 King's Bench Division 66, where it is said by Baelish J that a penalty clause may be disregarded as it is always disregarded and has become a dead letter, or from another point of view, a brutum fulmen. And a brutum fulmen is a meaningless thunderbolt. Now, that was from a decision of Justice Blackburn in Goddard and Gray. Nonetheless, notwithstanding all of this authority, Her Honour Justice O'Farrell concluded that had she found that this was a penalty clause, it would still nonetheless operate as a cap on liquidated damages. So it would be unenforceable for the benefit of the party entitled to $25,000 a week, but enforceable for the benefit of the person whose liability was capped at 7%. Now, I invite you all to read that decision and write your answers to Greenway Chambers, Post Office Box 1, Sydney, New South Wales, because I find the reasoning a little bit hard to wrestle with, but it's nonetheless out there, and I'm sure the inventive among you might be able to make something more of it than certainly I have at this stage. So that's me. There are 5 cases on liquidated damages and delay. Unless we've got any questions, I think our hour is done, isn't it, Shani?
I have a question for you, Frank, if I'm allowed.
I don't think you do, Brianna.
And it's about Tello, the first case you mentioned.
Yep.
I think this is possibly an unanswerable question, but I'll ask it anyway. Where's the line? And what's the presumption? Is the presumption that it is a genuine pre-estimate of loss and you have to rebut the presumption on the basis that you say, no, it couldn't be because it's nominal? And what is nominal?
Look, I think the short answer is, and as I said when I was looking at the case, it really is the converse of the penalty clause arising from genuine pre-estimate of loss. I mean, if you can show that the parties sat down, or at least they've turned their minds to the question of liquidated damages, and decided that, look, okay, $50 a day should about do it because that translates to $350 a week. I should be able to find a hotel room for myself and those that I've got to care for that price around the corner. That's fine. And if you wish to argue that the rate is indeed nominal and was not intended to exclude the right to general damages, if that can be proven, I would think that you would, well, firstly, it would need to be contended for or pleaded, depending on which court you're in, but it would also be useful to put on evidence to say, well, this rate was never discussed, I was never informed, and I know that the subjective notion of contracts and those sorts of things is not to be considered, but where you have arguments of penalty, as I think you would have arguments here, I do think that it may be worthwhile considering putting on some form of evidence, particularly if, and I think you could do this, it's the sort of parole evidence that might be admitted because of the uncertainty or ambiguity arising from a rate. But when you say, where's the line? Well, there. No, the line is really one to be determined by, well, what's the value of the contract? Who are the parties to it? What were they intending to achieve? So, in a contract worth $20,000, then $25 a day may not be unreasonable. In a contract worth 200 million, then you would think that a rate of, perhaps not £25,000, but $25,000 a day, for example, would be appropriate depending on what you're building. So it really is, as with all of these things, a matter of fact and degree. All right, well, can I just say on behalf of Richard and Brianna, thank you very much for joining our CPD. I know it was actually supposed to take place a little while ago, but due to the biblical floods that we had, we've had to put it off. I hope everyone's safe and dry. Good luck getting all your points, and see you next time.